This time is so unique because we have to implement a process, and just because our Constitution says that we could do this doesn't mean that each local municipality isn't going to implement a set of rules and the state isn't going to implement a set of rules. Just like in Denver, you can only grow a total of 12 plants as a caregiver. You know, they have certain restrictions in different laws depending on where you are. So it's very important that you know that, and right now it's all good because it's all in our Constitution. We could do whatever we want, it seems like, because that's the only law, but you know, it kind of depends on the person that you run into or that arrests you that makes that decision, and you will fight it like a DUI or anything else like that. So you want to make sure that you're not just going, you know, balls to the wall without knowing exactly what you're doing.
Well, I guess, but keep in mind in Amendment 64, too, if you're a current med licensee, to get that preference that we've talked about in terms of switching your license over to a retail license, it talks about having consistently complied with Section 14 of this article during the time you're licensed. So if you start getting dings, that's going to screw up your preference if you want to switch over to the retail market. So be aware of that as well.
Yeah, that's huge. Thank you. Who will be involved in assisting the Department of Revenue in the rulemaking process? And how will these individuals be chosen for these positions? Example, you know, who's going to have majority votes? Will it include non-legislative members? Will the meetings be open to the public? What input will they seek, and will they take outside opinions? So, Christian, go ahead.
Just a quick clarification. So there's going to be two things that go on. There's going to be the legislative bodies of our state implementing legislation, which has now been pushed, or it sounds like it's going to be pushed, it's not official yet, excuse me, into a bipartisan committee of the Senate, the House, the Governor's office, the Attorney General's office, and then hopefully a number of other people. Since we won, you know, it's like I would expect to have 6 people at the table for their 5. But we'll see. You know, we would assume to be credible that they would have to have someone on the proponent side, if not several people on the proponent side. Then there's also the regulatory process, which is going to involve rulemaking, much like we've seen in the past with medical marijuana. We're actually working on a adjustment to the rules right now. So I would think that they would ask a lot of the people that know what's going on, the stakeholders that exist now, about that process. But the big thing is all of these things are unknowns, and when the time does come that they name this legislative group or this, you know, revenue group, again, stand united, and we'll tell them that the will of the people is not being represented at the table. Governor Hickenlooper, you got up there and told me no. You told me I was going to ruin the state and ruin the kids and ruin everything else. I respect, look, yeah, and he's the executive, so he's stepped up and said, well, I'm going to implement the law even though I disagree with it. The Attorney General's office, we all know that he's not been a fan, and he has been a vocal opponent, but he's going to do his job defending this law. But he also has a seat at the table. The legislators, you know, they should understand that in all of their districts, we got a majority of those districts, you know, but there's also political concerns there. So that's why we need to be very assertive in making sure that we have a substantial role, which I expect we will, because if we don't, we'll tell them that it's not credible with our, you know, we'll get 1.3 million Coloradans behind us telling them that.
But as it relates to the rulemaking process, you know, government approaches rulemaking really by the letter of the law, and that process is varied based upon the administrator that's really at the helm. And what Christian said, at this point, you've got a legislative session that's going to start in January. They will define some parameters and put some things in place as required by the amendment. And they'll probably go a little bit further than that. And I would advocate that it is at that very step that the industry really needs to get a voice, and they need to get someone's ear, and they need to be involved. Just real briefly, the Administrative Procedures Act in our Title 24 in Colorado really sets forth the rulemaking process. And I can tell you that as a matter of law, it requires that a notice be posted. There's a time frame associated with that, and that a hearing be held, and that written testimony, written comments, as well as verbal testimony be taken. And the agency only needs to have what they call a rational basis to promulgate a rule. Different standard, a different legal standard than most are used to. Certainly it doesn't rise to the level of being a criminal standard. But with that said, really where I'm going with that is it's really subject to interpretation. My guess is that they will probably pull from a number of the regs that are already in place that are used for the medical marijuana side of the house. Many of them are quote unquote rational. They've been in law now for just about 2 years, a little over 2 years. Some of them are problematic. It's certainly not a perfect process, but I can assure you they'll pull from that. But the critical part here is there's no requirement that they put a workshop together. There's no requirement that they seek input outside of a hearing from the industry that they intend to regulate. I can't imagine good government implementing a process without seeking that input from the people that you're going to regulate. It makes no sense to me, and that's the way I did it my entire career. It's the only way that it effectively works. But they only need to have the rational basis. The other thing you need to know is the Amendment 64 requires that these rules be promulgated no later than July 1st, 2013. That time is going to be here before long. And I'll tell you, the legislature starts in January. They're going to have to put notice up to meet that July 1 deadline, I believe, by February 1st. That means the hearing has to be held by March 1st. You're on the fast track then to meet that July 1 mandate. And it's just, I would just encourage that who's ever going to be at that table really look at those deadlines, those timelines for the APA, for the rulemaking process, and get a voice. But if you can get involved, get seated very early in that legislative process, and a legislator says to the executive director of the Department of Revenue or the head of the agency that's going to regulate this industry that they would like to have a work group put together, chances are politically that may happen. So something for you to consider moving forward.
What should current MMCs expect to see during this transition and implementation process, and what is the timeline? What likelihood will marijuana be similar to medical marijuana? Can we have retail and MMJ centers in the same location? And if I have 6 medical marijuana centers, does that mean I'm eligible to apply for 6 recreational licenses?
Well, I think the 800-pound elephant is really going to drive the answer to this question, and that's the unknown, and that is what's the federal government's response going to be to Amendment 64. Clearly, they have left the medicinal side of things alone for 2.5 years in this state, and I think that's very telling as well as to where their position is or what their position is with this. But nonetheless, until that question is really answered and until the legislature acts and gives some parameters and the rulemaking process begins, the key is clear and unambiguous compliance with state law. And I cannot overemphasize it. If you're on the medical side of things, you've got to follow the letter of the law. Don't give anybody a reason, obviously, to cause a federal action and intervention of any sort at this point. Very early on, Christian used the term responsible. It's about a responsible industry going forward, and I couldn't echo that enough.
Okay, we passed a bill to regulate marijuana like alcohol. What similarities do these two industries have, and what will be different? Was that a title to help voters understand legalization, but would be conflicting if they were regulated the same, or how do you think that's going to work?
When you think of alcohol prohibition ending, you had the rise of large breweries, large distilleries. Over the past 70 years in, say, Denver and other communities around the state, things have gotten a lot better from my perspective in terms of what this means, in that when I walk into a liquor store, there's a broad variety of products for me to choose on the alcohol levels, the beer level. Right now, there's 4 new brew pubs or tap rooms or whatever they are that have opened very close to my house that are, I think a net benefit to, our communities, and I think it makes it an interesting place. And, the concept of this being regulated just simply retail stores that are like liquor stores and large producers that are independent, I think that there's much more to it than that. And I think that in terms of preserving all the work that you guys have done that are in the industry out there, accepting and acknowledging the fact that you were the ones, I was telling this to excise and licensing director today. I said, the bootleggers or whatever, we're not going to kick them out. We're going to protect them, and we're going to make what they've done, preserving their genetics, their techniques, their ideas. We're going to do everything in our power to preserve that concept going forward. And for those people worried about the very large grow coming in and wrecking the market or doing whatever, I think we have credible arguments that under our alcohol code, it doesn't have to go that way. And people may or may not agree with me on that. I'm simply making the point that there's a lot more to it than the very basic concept of crap, now I'm gonna have to compete. I spent all this money building grows, I spent all this money doing this and that, and now where am I gonna stand in 6 months? I think there's a lot more to it.
The Department of Revenue reverts back to, well, we're going to do this like we do in alcohol. And that's something we haven't traditionally heard in some of the rulemaking here. But whether it's to the excise licensing or other issues, that's something that we need to keep in mind, and through Mike's organization and other lobbyist efforts, push that effort to, get away from some of the 1284 shackles and get more to like the regulations for alcohol.
And the alcohol industry doesn't have a 70-30 requirement. It doesn't have vertical integration. The legislature got it exactly backwards. They said the corner liquor store has to own Coors Brewery. That's what the legislature foisted on us. Those mistakes will be avoided this time around if the legislature's even involved with this. Because if you read the amendment that the voters passed, it does not grant the legislature any power to create these regulations. In fact, it specifically says the Department of Revenue is going to create the regulations. The Department of Revenue did not create the 70-30 regulation. That was the Colorado legislature. The Department of Revenue did not create vertical integration. Again, that was the Colorado legislature. So what you're going to see and how this is designed, it's going to be much more like alcohol than it is like medical marijuana. We've learned our lessons with medical marijuana. Some of them were tough lessons, some of them were good lessons. But the way this is structured is it mirrors the alcohol code and the alcohol regulation, which makes a lot of sense in some ways. Of course, there are problems with that, but far fewer problems than what we've seen with medical marijuana. And you have this backstop in Amendment 64 that no regulation can be unreasonably impracticable. So from a legal standpoint, that's a new concept that is not merely rationality review. And this is in the amendment. It says that something is unreasonably impracticable if it requires such a high degree of investment of risk, money, time, or any other resource or asset that the operation of a marijuana establishment is not worthy of being carried out in practice by a reasonably prudent business person. The other thing that you don't see in here that's restricted are restrictions on people's distant past, all right? You made a mistake in 1995 and picked up a felony for cultivation of something that's perfectly legal now, by the way, perfectly legal, that you're not shut out of this industry like you are with medical marijuana, which was ridiculous. The legislature made that up. There are good people who know how to grow marijuana, and they picked up a charge here and there. We should bring those people back into this industry because they have knowledge that we can use. There's also no restriction whatsoever on out-of-state investment. This is what the legislature did. The legislature said, we don't want you bringing in money and jobs to our state from out of state. That is basically what the legislature did when it passed 1284. It was ridiculous. It was utter malpractice. We should be attracting business to Colorado. And any other business, we do attract to Colorado, and we give them tax breaks to bring their businesses to Colorado. So that residency restriction is not here. Obviously, those people who are here now on the ground floor are in the front seat. You have the preference if you're an MMC owner. And we designed it that way, and there's a good reason for that, because it was a way to get the industry behind this, which they were. So that was a good thing. So you're still in the driver's position, and you can bring in investment from out of state.